Thank you for the kind words, Brooke. I'm really looking forward to this conversation. And this is going to be, I think, a wide-ranging conversation that you're all going to benefit from. Touching upon the federal nature of these United States, where you have a sovereign federal government and sovereign state governments. And I think you're going to see the comments kind of woven about that lattice work. And so today we're going to start with Mario, because he was so involved in that recent ObamaCare ruling at the U.S. Supreme Court. In fact, Mario, over the past year or so, has been engaged in writing a number of briefs and articles with the noted constitutional law expert, Professor Richard Epstein. And so what I'd like to ask you, Mario, is that the court appears to have agreed with some of your arguments. And I was wondering if you could enlighten us as to what exactly the impact of the ruling was.
Well, so the Supreme Court has said for a long time that the federal government cannot command the state government to do anything. And that's a wonderful rule. It has a very big exception, which is that the federal government can come up with assistance programs, financial assistance for the states, and it can make those assistance programs contingent on the states complying with, for example, 97 different requirements that a state Medicaid program has to comply with in order to receive federal funds. The Supreme Court has said that because that's a voluntary program, the state enters into it voluntarily. It can voluntarily choose for its tax dollars to go to California instead of to come back to Texas, that it's not coming here. We've been saying for more than a year and a half since our first briefs in the Court of Appeals level in the ObamaCare case, no, that's wrong. When the federal government taxes money away from the states and offers to give it back to them only on condition that they comply with a series of requirements, what's happening is coercion, and it's in effect commandeering. It's the subversion of state governments for the implementation of policies that are not the ones that Texans prefer. They're the ones that people in California and New York prefer, and use the federal government to impose on everybody else. And when the case arrived at the Supreme Court, we tried to be reasonable. We said, look, we're not asking for the moon. Let the conditions apply to how the federal money is to be spent. But don't let the conditions apply to collateral state policies to be used as leverage for new programs and stuff like that. And this is clearly a new program. Well, I thought that was a valiant and noble argument that had about that much chance of succeeding. But actually, the Supreme Court generally sort of agreed. It said when the funds attaching to the existing Medicaid, when the conditions attaching to the existing Medicaid funds have to do with an entirely new program, they call the Medicaid expansion in Obamacare a transformation, not just an amendment of the existing program, then what you have is, and it involves 20% of the average state's budget, then what you have is a gun to the head. That's coercion, that's inclusive. And so what we're doing now at the foundation is, those conditions, that cross-conditioning of different programs is that there are hundreds of federal assistance programs that have conditions like that. And so we have to see which of those are similar to the one that was struck down in Obamacare. Maybe there won't be many, maybe there will be lots. We have to take a very careful study, and it's going to be very time consuming, but it's worth it because the state might have just gained a lot of flexibility that it didn't know it had. Whatever the result, though, one thing that we've learned is that the intermingling of state and federal finances has been really catastrophic for the United States. It's been the main reason, really, why the government spending at all levels of the United States has ballooned in recent decades. And it's something that's got to stop. Whenever you hear federal assistance programs, it sounds nice, but it's terrible. It's terribly corrosive for the Constitution, for the independent functioning of state governments.
Well, Attorney General Abbott, you were actually in the U.S. Supreme Court chambers when the ruling came down. Could you describe what that was like and what you were thinking of when this story came out?
Let me give you an expansive answer to that question, but let me cover two preliminary grounds first. First, I want to applaud the TPPF for helping provide both muscle and intellectual might to our argument in the ObamaCare case, as well as so many of the other legal challenges that we are waging. If you go back in time to what generated the attorneys general from around the country getting involved in launching this lawsuit against ObamaCare in the first place, it generated from papers that were written by the Heritage Foundation, another intellectual think tank of conservative ideas based in Washington, D.C. As we got into it, however, we were propelled along the way because of writings, analysis that were provided by TPPF, as well as the advocacy brief that you heard that was filed here. The state of Texas, and I can tell you the entire country, benefits because of the work that is generated by this foundation, and we appreciate it, Brooke, for you and your entire team. Second thing I'll tell you, and that is something that a lot of speakers don't tell you, and that is I would like you to get out your cell phone or your mobile device and add me to your Twitter account. Now, as you're getting your phones out, I'll tell you the benefit of doing so. As you mentioned, I was at the Supreme Court when the decision was rendered. I was also at the United States Supreme Court for all 3 days of the oral argument that was made. Had you been one of my followers at that time, you would have gotten a play-by-play update of what was going on in the United States Supreme Court, and you would have been able to better predict what the eventual outcome would be. So I know what you're thinking. Well, General Abbott, I'd like to follow you, but what is your handle? What is your address on Twitter? It's Greg Abbott _TX. That's GREGABBOTT_TX for Texas. Also, had you been following me, you would have known before the media had known what the decision was and what our appellate decision was going to be with regard to the voter ID case. You can learn all kinds of things about what's going on with regard to challenges if you follow Greg Abbott _TX. But now for the more expansive answer. We got to understand where we've been and where we are as a result of what was announced when I was in the United States Supreme Court. Remember this, when we filed this lawsuit, we were considered to be a renegade group of 13 state attorneys general, highly ridiculed by Nancy Pelosi, by Harry Reid, by all the foundational leaders in Washington, D.C., who asked the question, what authority do state attorneys general have to file a lawsuit against the federal government for something like health care? And of course, their ridicule was heaped upon by law professors around the country, by political pundits, by the media, all of whom scoffed at the notion that some state officials can try to bring down a complete overhaul of our healthcare system. Well, that renegade group of 13 state attorneys general soon expanded into 26 states, more than half of the country, suing the country that tries to regulate them. And as we headed toward trial, we were still ridiculed. Well, the ridicule faded when a federal district judge ruled in our favor and struck down ObamaCare. And then the ridicule turned into great concern and hand-wringing when a federal court of appeals upheld that decision. And then it got even worse for the critics when, during the course of the oral arguments that lasted 3 days, it was described by Mr. Tobin on CNN for the Obama administration as a train wreck. And then on day 3, it went from being a train wreck to a plane crash. This was an argument and a decision that was monumental in the history of the United States Supreme Court. Well, let's talk about where we are based upon what happened in that decision that I attended when the court read it. I consider it to be somewhat like a comment that Brooke made in her introductory comments, and I'm not sure, Brooke, if this is what you're referring to. I think it may be. Brooke said that we Texans are accustomed to facing a loss, but coming back and persevering until we achieve victory. You could use that as a way of describing what happened at the Battle of the Alamo, which is what you were referring to. And I bring up that comparison because I view this somewhat like the Battle of the Alamo. It was a catastrophic loss for the United States and for individual liberty. And I believe that if the ruling stands, it will be an albatross around the necks of individuals in the country for decades to come. However, like the Battle of the Alamo, it gave rise to a battle cry that may lead to an ultimate victory at war. The battle cry here is, remember Obamacare. I have been at rallies across the country and across the state. And you can see in presentation after presentation, there is one line that resonates more and gets more positive reaction than any other line. And that is, repeal Obamacare. And the reason why I bring that up, and that's because on that day that I was in the courtroom, there were 9 justices who cast their vote that day. That vote, however, is not the final vote. The final vote on this is going to take place about 60 days from now, when the American people vote. Because you've heard Mitt Romney campaign and Paul Ryan campaign their promise, and that is that if they are elected, they will repeal and replace Obamacare. That can be done very easily, because now that Obamacare, as we have learned, is the Obama tax, it doesn't take 60 votes in the U.S. Senate in order to get it passed through that chamber. It's going to take 51 votes. If Mitt Romney wins, it should mean that there will be a majority of Republicans also in the United States Senate. It will pass there, will pass in the U.S. House, and Mitt Romney will sign it, repealing and overturning Obamacare. But there are other ways in which this is also a remember the Alamo type moment, because there are other battles that have been won in the war against Obamacare. And those battles are some lines you need to better understand about what the opinion says. Remember the very last line of the opinion issued by the majority in Obamacare, and that is that the Court of Appeals decision is affirmed in part and reversed in part. The key phrase here is the part that was affirmed. Even though we ultimately lost and Obamacare was upheld because Chief Justice Roberts decided that Obamacare was a tax, and Congress clearly has the authority to tax and spend, there were lines drawn in this opinion that look like a Tea Party manifesto. If you look at what the court said about the Commerce Clause, this is a battle that has been waged for the better part of an entire century, with the results constantly going one way, in favor of expanding the ability of the federal government to regulate through the power of the Commerce Clause. This was the first meaningful reining in of the Commerce Clause by the United States Supreme Court. If you look at Chief Justice Roberts' opinion, which was the decisive opinion, he repeatedly refers to state sovereignty, the 10th Amendment, the Federalist Papers, James Madison, all hearkening to the fundamental tenet of this government, and that is that the federal government is intended to be one of limited power, with most of the power being reserved to states and to individuals. So we had a meaningful victory by the court agreeing that the Commerce Clause was violated by the United States Congress, by Congress trying to force you to go out and purchase a product against your will. The second victory is what Mario was talking about, and that is with regard to Medicaid expansion. This is the biggest win for state sovereignty, maybe in the history of the U.S. Supreme Court, certainly I think in the last century, where the United States Supreme Court clearly said that states are separate sovereign entities that have the independent power to govern themselves, and that the federal government cannot co-opt states to help achieve the federal government regulate its people. And by allowing states to win on the coercion doctrine, by claiming that states cannot be forced by the federal government to expand, in this case, the Medicaid system, even if the states don't want to, it gives states new power, new ability, refreshed authority, basically to just say no to the federal government as it concerns our independent authority to govern our own bottom line. So even though we're battle-scarred from the ultimate decision in this case, you can walk away from here today and take away from the case knowing that the United States Supreme Court did more in this decision to rein in an expanding federal government than in any opinion I have ever read come out of that court.
General Abbott, maybe you can expand on that theme. You've been pretty active of late in the courtroom defending the prerogatives of Texas with regards to the Environmental Protection Agency and rules regarding air pollution, etc. Could you talk a little bit about EPA's regulatory overreach?
I can, and once again, not to overbeat a drum, but we truly benefited from papers written by TPPF with regard to environmental regulation and the EPA, and having them side by side with us intellectually provides incredible support. But if you saw what happened in the month of August, we had two huge wins, one out of the 5th Circuit Court of Appeals, another out of the D.C. Circuit Court of Appeals. One concerned the cross-state air pollution rule. This is a rule issued by the EPA preventing entities from within one state, instead of Texas, from polluting across state lines to another state. Not unreasonable. Okay, but exactly which state did entities in Texas pollute? Was it New Mexico, Oklahoma, Louisiana, or Arkansas? The answer would be no, 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 and no. Well, maybe Texas facilities polluted some state that was adjacent to one of our neighboring states. Again, the answer would be no. What the EPA concluded is that somehow entities in Texas were polluting the poor citizens of Granite City, Illinois. And how the EPA was able to pull that out of the hat, we have no idea, nor does the Court of Appeals. They agreed that the EPA had acted irrationally and had abused its power and authority and struck down that rule and regulation. The other one that we won on was called the Flexible Permits Rule. This is a rule that was created under the Ann Richards administration here in Austin. It survived the Clinton-Gore administration, lived on through the Bush administration in Washington, D.C., and only under the current administration did they decide, well, listen, that flex permit system that the good folks down in Texas are doing, we just don't like that anymore. And so they struck it down. And once again, the Federal Court of Appeals said that the EPA had overreached, acted beyond the power that it has, and it ignored the reality of the way the Clean Air Act was structured. And that is the power given to the states to be in charge of determining its own regulatory pathway. So we've had two big wins in the Federal Court of Appeals against the EPA, setting the theme once again, whether it be those two wins in the Supreme Court under ObamaCare or these two wins under the EPA. Courts are increasingly striking down actions by federal authorities as reaching too far into the powers given to the states to regulate themselves.
Thank you. We've heard about some defensive actions that you've taken as Attorney General for the state of Texas, defending the prerogatives of the state of Texas. Can we shift now? Maybe Mario, is there a statutory solution to this sort of thing, this federal overreach that seems to be a constant theme here today?
Well, let me just say, continuing on the EPA front, the problem on the EPA front, the basic problem is that Congress has figured out that it can escape accountability for its policies by hiding its power inside of executive branch agencies, basically. Just like through federal funds to the states, it's hiding its policies inside of state governments and escaping accountability for them that way. And it's become a big problem. If the greenhouse gas regulations that EPA adopted over the past year and a half had been, somebody had tried to present them in Congress, they would have been laughed out of committee by the Democrats. I mean, they would have never had a chance in Congress. And that's why we need to reassert it, and as your friend and mine, Ted Cruz, has pointed out, what happens when Congress delegates rulemaking authority to an executive branch agency is that the power of people and through their representatives in Congress gets diluted. They lose the ability to shape those policies through a normal legislative process. And so what Kathleen White and folks at the foundation have worked very hard to get Congress to look at is the REINS Act, which would require congressional assent in both houses of Congress to any major rule. Major rule is defined as any rule that would have an impact of $100 million or more on the economy. And whenever EPA opens its mouth to say anything about anything, it costs like $5 billion. So this is the kind of thing that we're going to need, and we're going to need to push hard for moving forward. But the key thing is to bring accountability back to where it belongs, which is with the responsible members of Congress.
If I could follow up on that, add one thing. I view the most offensive, or one of the most offensive things about the ObamaCare decision is two-sided talk about that accountability. On the one hand, Chief Justice Roberts did say, the purpose of these laws is to hold lawmakers accountable. He said in the opinion that if the general public doesn't like a law like Obamacare, it's up to the people to vote those lawmakers out of office. Here's the problem. It was only after the law was passed, after the law got through the appellate system, did the courts then describe Obamacare as a tax. We all know that if the members of Congress have put this up as a law, as a potential tax, vote in favor of it or against it, there's no way they could have passed that law. In general, lawmakers would not have passed for a tax increase that hits heavily on middle class. But secondly, that tax would have weighed heavily against the president's admonition not to raise taxes on people who make less than $250,000 a year. So a post-event court description of a law or recharacterization of a law as a tax doesn't so much hold lawmakers accountable as it does requiring them to call it a tax up front.
If I could just jump in on what was really infuriating to me was that the administration the court had just said this is a tax. And as soon as Axelrod and everybody went up in front of the TV cameras on Sunday morning, they said, no, it's a penalty. And, get your story straight. If it's a penalty, then it's unconstitutional. That's what the court just said. And so...
Well, there you go. Mario, you've been the director of the Center for 10th Amendment Studies for 2 years now. And we've heard kind of the theme here, the 10th Amendment and its place in our federal system of government. Does the 10th Amendment matter still?
Yeah, I've come to, I've spent 2 years, like you say, thinking about this. I had a great opportunity, thank you, Brooke, and others at the foundation, to really think about this and to read back to colonial history and backwards and forwards. And I think that I've acquired just an elementary sense that what the 10th Amendment was supposed to protect was the freedom of political communities at every level of society. It wasn't just, it talks about states and it talks about individuals and how the power is not delegated to the federal government or reserved to those, as the case may be. But in reality, it was talking about the things that Yuval Levin talks about in a recent issue of National Review, which is all of the civil society in between the individual and the federal government that the Constitution was meant to protect and give voice to. The idea of the Constitution, of the federalism in the Constitution, is let the national government deal with national stuff and let local communities deal with local stuff. And when the New Deal first arose, one of my favorite writers, Walter Lippmann, had been a supporter of Franklin Roosevelt, became very critical of the Roosevelt administration and started talking about how, you, Mr. President, criticized democratic dictators in Berlin and Rome. This is during the 1930s, obviously. But then you are propounding a government based on the tyranny of transient national majorities. And that's, an arcane sounding phrase, but when you think more and more about Obamacare, and too bad they don't make Walter Lippmann's anymore. We don't have Thomas Friedman. It's not the same thing. But anyway, when you think about that, you realize that what Obama has really tried to do, and what liberals have tried to do for decades, is to stitch together constituent special interest groups to take over the government as an extractive institution, and to really put it at the service of a transient national majority. And we hear living constitution and things like this, it's all just a way of escaping the limitations and the protections for minority political communities that the Constitution was meant to guarantee. And you know, for me, I like the federal government when it does what it's supposed to be doing. When the federal government comes in and says, Dormant Commerce Clause, State X, you're discriminating against interstate commerce, that's good. Because every government has a tendency to collude, every government has a tendency to serve its own special interests, and the powers of the federal government to prevent that happening at the state level are very important. But that's not the problem that we're dealing with now. The problem that we're dealing with now is a federal government that has found ways to exercise powers far beyond the limits of the Constitution set up any interpretation of the Constitution. And so that's why the 10th Amendment matters now, is to keep things that are local at the local level so that self-government and freedom can truly be preserved from what we see in administrations like the current one is the transient tyranny of the national majority.
So then to you, General Abbott, 2 questions, and then we'll go to Q&A. In your mind, does the 10th Amendment still matter, and where do we go from here?
The 10th Amendment has been challenged for a century. It mattered more when it was written, and in fact, it was kind of ironic because if I recall when it was written, not that I was there, but if I recall, the authors of it said initially that we don't really need the 10th Amendment because it was patently obvious that all those powers not specifically given to Congress did reside in the states and in individuals. Obviously, over time, the 10th Amendment became more obvious that it was needed. However, as Mario articulated, for much of the past century, it has been eroded by judicial decisions. One of the bright spots that can be found on several occasions in the ObamaCare decision were references to the 10th Amendment, which shows to me that there is an understanding on the high court, and I think there's a greater understanding across America, that the 10th Amendment has growing resonance and maybe is coming back to life a little bit.
And so where do we go from here, though? How do you see this path working itself out? Statutorily at the federal level, more judicial action?
Well, speaking personally, it's going to work out through more litigation. Let me tell you the way that this is applied. You obviously know, because we told you, that we won in Obamacare on the issue that Congress violated the Commerce Clause by trying to impose the individual mandate. We're looking at potential litigation asserting the limitations on the Commerce Clause. Most of the litigation that we're focused on right now, or potential litigation, is because of the U.S. Fish and Wildlife's attempt to create new endangered species that will put limitation on a state's ability to conduct affairs within a state. We believe, for example, with regard to the lizard in West Texas, we were geared up to file a Commerce Clause claim against U.S. Fish and Wildlife on that one. There's some new attempts by the U.S. Fish and Wildlife to declare certain species as protected that may give rise to further litigation. Bottom line is we will look at the seeds that have been planted in the Obamacare decision, both with regard to the sovereign powers of the state under the Medicaid component of the decision, and with regard to the limitations under the Commerce Clause that limits Congress's ability to regulate the states. We will use those ideas to look at future potential litigation that limits federal power and intrusion into our lives.
Can I just say something else? And just, because I was raised in a military family, and my people who raised me are very practical people, and I've never given a lot. Growing up, I didn't give a lot of weight to academic theories and stuff like that. But I've got to say, in the 1980s, Richard Epstein really was the only person saying that Wickard versus Filburn was not only wrongly decided, but a preposterous decision. And 10 years later, law professors and law students all over the country were saying it. And then a Supreme Court Justice, Clarence Thomas, said it in a dissenting opinion, in a concurring opinion in the Lopez case. And now, in the new book by Justice Scalia, by the way, has sort of concurred with judgments that reaffirmed Wickard versus Filburn over time many times. And in the preface of his book, he says, For some of us, wisdom has been long in coming. And that's, so even Rehnquist, justices like Rehnquist and Scalia, have taken a long time to understand that these doctrines, South Dakota versus Dole on the conditional spending front, Wickard versus Filburn in the Commerce Powers case, are not workable and not compatible with constitutional government. They can't work at all. The attempts to try to make them work only sinks a deeper hole. And so it's very important to be out there with law. The Central Front really is law review articles. It really is the war of ideas. Where you're coming out and convincing people and convincing a new generation of lawyers and future attorneys general to look at these cases and realize that we have to fix these doctrines. Otherwise, they're going to hang like millstones around our neck forever.
All right, we have about 7 minutes for questions, and in the audience we have, well, I was going to say interns, but it looks like we have an actual employee of the foundation here. I was going to say a word about our interns. We typically have a tranche of about 3 different crops of interns that come through, and it's delightful to have them. And so if you want to ask a question, please raise your hand so that I can recognize you. And let's go over here in the front, because my peripheral vision caught you first, sir. So please tell us, to whom are you addressing your question? And let's hear more of our speakers.
Thank you, I appreciate that. This is for General Abbott. Sir, should the worst case scenario happen and Mr. Obama is reelected, the subject is nullification. Nullification of Obamacare here in Texas, is that an option? And if so, how good an option? Can we nullify it here in Texas?
Our focus is on waging legal challenges against it. You may know, may not know, we already have another lawsuit that was filed earlier this year challenging a part of Obamacare. Another part of Obamacare is that the only person who was right about it all along was Nancy Pelosi, who said they had to pass Obamacare to find out what was in it. And what she really means and what we're finding is that there are these new regulations that are issued, typically by the Health and Human Services Department, that really give you the details of what the Obamacare regulations are. As those arise, they will give rise to additional litigation where we challenge Obamacare through the court system.
I think I saw a hand over here that was prominent.
Just for General Abbott, with respect to the redistricting case, do you think there's any chance that the Section 5 of the Voting Rights Act can be a part of the court's decision?
On the redistricting case, remember this. The last time we got a court decision on redistricting was last November. A month later, we appealed it to the United States Supreme Court, and a month after that, we did something that's hard to do these days. We got a unanimous decision out of the United States Supreme Court overturning the lower court's decision on redistricting. And so we had the unique ability to bring together Chief Justice Roberts, Scalia, Thomas, Sotomayor, and Kagan all in one. In order for the Supreme Court to take a case like that and overturn it, it requires several different dynamics. One of which is to have a lower court decision that is extreme, that goes beyond the pale, that truly violates the law and precedent. We think that the decision that was issued last week in redistricting satisfies all those criteria. Let me give you several quick examples. Never before in redistricting litigation has the Supreme Court approved what are called coalition districts or crossover districts, or the requirement that new districts be created in order to satisfy an increase in racial minority population. Those 3 reasons alone, there's more, but those 3 reasons alone mean that what this court decided is completely unprecedented, goes beyond what the U.S. Supreme Court requires, and as a result, I think the Supreme Court should overturn what this court has done. We've already filed our papers for appeal in the U.S. Supreme Court on this case. Now, the other issue that you talked about directly, and that is, will the Section 5 component of the Voting Rights Act stand? The Section 5 component is the pre-clearance or pre-approval component that basically applies to just 9 states. Texas is one of them. It doesn't apply to mostly 41 states. And in a decision issued by the U.S. Supreme Court about 4 years ago or so, a case involving the Austin Municipal Utility District, the court hinted at that time that the pre-clearance component of the Voting Rights Act may no longer have viability. When we were at the United States Supreme Court this last January for oral arguments in the first redistricting case, unprovoked from the bench, Justice Kennedy volunteered that it looks like Texas is at a comparative disadvantage in relation to other states because of Section 5 pre-clearance. Because of that, I would say that the court has basically given us an invitation to raise the constitutionality of Section 5, which we are doing, and perhaps strike down the pre-clearance component of the Voting Rights Act.
Thank you very much. Loyola. We want to be respectful of your time, and I think that we're going to turn things over to our president and CEO, Brooke Rollins, to let us
close us out. One more round of applause, please. Thank you so much. I kind of sit in my seat and try to think to myself, you know, when your friends ask, what did you do for lunch? Oh, I had a constitutional conversation about the 10th Amendment and blah, 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 blah. But this is so, I'm sure some of you have these conversations too. This is so important to the future of this state.